Hello everyone and welcome to this video tutorial in which we're going to be doing some A-level law revision for your tort exam, and today we're going to be looking at this scenario question on occupier's liability. As you can see, there's quite a lot going on in this scenario, as is often the case in your law exams, so I'm just going to pause this, highlight the key issues in the scenario so that we can talk about what you need to apply. Okay, so you can see that I've done here what I advise you to do in the exam, and I've highlighted some of the key issues that are cropping up in this scenario. So firstly, we've got our character Arthur, who's inherited a house. So he's potentially going to be our occupier. He moves in and he gets this company, Askew Alterations, to do some work. He holds a party, and then we've got Basil and a 5-year-old child, Clara, attending. Clara's going into a room where there's a danger do not enter sign. Basil gets an electric shock, and then Cedric goes into the cellar looking for some wine and slips on a cork. And you're being asked to advise Basil, Clara and Cedric whether they have any claims against Arthur. And this would be under the law in occupier's liability. I do have some other videos on my channel on occupier's liability if you need a refresher on the law, and if you need a refresher on how to use that IDEA exam technique for answering this. But in this video, I just want to scroll through and show you an answer to this question so that you can see what a good answer would look like on this. You can see I've colour-coded. Now I've put some subheadings in this answer in purple. Now I wouldn't advise particularly you to use subheadings in the exam. I mean, you can if you want to, but I prefer not to. But I've included them on the video just so you can see where I'm discussing certain elements of the Occupiers Liability Act 1957 and 84. So you can see I'm going to talk about occupier premises and the standard. I'm going to talk about children, professional callers, etc. So I've highlighted that for you. I've also put in black font wherever I'm just giving a legal fact, a rule, a principle, a case. And the red font is where I'm applying that back to the characters, and I've highlighted in yellow key cases and sections from the acts just to hopefully make that stand out a little bit better for you. So to begin with, I'm going to identify that our character Arthur might be liable to these characters under the Occupiers Liability Acts 1957 and 84. And quite often, like in this scenario, you'll have people who enter under the 57 Act but then later become trespassers. But luckily for us, a lot of the law on the occupiers liability is the same, so we can go through that before we deal with the 84 Act. So I'm going to start by saying that occupiers liability is governed under the two acts I've mentioned, and that firstly we must show that Arthur's an occupier, and section 1.2 of the 57 Act says that we need to refer to the common law on this. So according to Wheaton-Lacon, Arthur's going to be an occupier because he owns the house. He's inherited it from his mum. The next issue is whether we have premises for the purposes of the Act, and under section 1.3a there's a broad definition, but Arthur's house is clearly going to be premises under this Act. Then I'm on to the standard owed, and I'm going to say that it depends on whether they're lawful visitors or trespassers. Under section 2.2 of the 57 Act, the standards to take such care as in all the circumstances it's reasonable to ensure they'll be reasonably safe. Under the 84 Act, the duty is not to injure a trespasser. So remember, there's a lower standard of care if somebody is a trespasser compared to if they're a lawful visitor. And in applying this back to the scenario, I've said that Basil, Clara and Cedric certainly all start as Arthur's visitors under the 57 Act because they were invited to come to a party. But Cedric later becomes a non-visitor when he exceeds his permission going to the cellar to look for some wine. So children, we need to apply section 2.3a, which states that an occupier must be prepared for children to be less careful than adults. And you could talk about the case of Phipps and Rochester Court here, where it was held that the responsibility for children of, quote, tender years rest primarily with the adult accompanying them. Now, Clara's a child because she's only 5 years old. It might mean that Arthur was justified in relying on Basil to look after Claire. In terms of our standard ode to professional callers, that's governed under section 3b, and they have to guard against risks ordinarily incident to their work, like in the case of Rolls and Nathan. I wanted to put this section in to show the examiner that I know it, but none of Arthur's guests fit into this particular category. We've then got independent contractors coming from section 24b, and this is going to be important for us because we've got that issue with the skew. Now, this section says that where damage is caused to a visitor by danger caused by the faulty work of an independent contractor employed by the occupier is not liable for the damage if it was, and we've got a number of steps here, reasonable to trust the work to them, the occupier took reasonable steps to check that the contractor was competent, and the occupier took reasonable steps to check that the work had been properly done. So Basil suffers an electric shock as a result of the faulty electrical work done by Askew Alterations. Now, applying what we've just discussed here, I've put that it seems appropriate to trust an electrician with the electrical work. So the issue is whether Arthur could be expected to have inspected it. And this is where you're going to need to apply some case law. So in Hazeldine and Dorr, it was held that an occupier can't be expected to inspect work of a technical nature. And that involved the electrical work on a lift, if you remember. But if the work is of a more routine nature and the occupier could check whether it had been done efficiently or not, then the occupier may be expected to check it. So in Woodward and Mayor of Hastings, the independent contractor was clearing snow off a step. Now, clearly, you don't have to be any sort of expert to be able to see whether the snow has been cleared or not. Now, applying these rules to Arthur's case, it does seem that Arthur's discharged his duty in relation to Basil and the electric shock, because it seems reasonable to employ Askew Alterations, although you could discuss here there may be an investigation into whether he took reasonable steps to check they were competent or not. We can't really expect Arthur to inspect this technical work, so Basil can potentially sue Askew Alterations in negligence rather than going after Arthur in occupier's liability. The next thing to consider are warnings, and under section 24A of the 57 Act, a warning can discharge the duty of care. And you might like to talk about the case of Derby and Tomlinson and Congleton. Sorry, I've just noticed I've not highlighted those. But you could discuss the fact that in Tomlinson, the claimant was volenti when he ignored warning signs and dived into a lake. Now, we need to consider the sign in Arthur's case. So Arthur could argue that the sign, "Danger, do not enter," is a warning that discharges his duty under this section. But to achieve this, the warning must, in all of the circumstances, enable the visitor to be reasonably safe. And the sign doesn't seem to be a warning at all, in that it makes no attempt to actually describe what the danger is. The danger isn't an obvious danger, like it was in Derby and the National Trust, and the sign wouldn't be enough to discharge the duty owed to a small child, nor will it turn Clara into a non-visitor. So this is the bit that I referred to earlier on when I did mention, if you recall up here when we were talking about the standard ode, I mentioned that Cedric later becomes a non-visitor when he goes to the cellar. Now that we're applying this warning situation to our character Clara, we can say that actually she's not going to be a non-visitor because it's going to be insufficient to discharge this duty owed to a small child. And it's also going to be insufficient with regards to Basil because the notice seems to be insufficient as a warning. It doesn't suggest that there's a problem with the electrics or anything like that. So it wouldn't be enough to make the visitor reasonably safe. So with regards to Clara, it seems that Clara's not going to be able to sue Arthur because Basil should have been looking after her if we're applying Phipps and Rochester. She's a child of tender years, I would potentially argue. However, she may be able to sue Basil in negligence because Basil owes her a duty of care under the normal Donahue and Stevenson principles. And with regards to Basil, it seems that he can sue askew alterations in negligence rather than Arthur because it was reasonable for Arthur to entrust the work to them. And now I'm going to deal with the trespasser situation that we recognised earlier. So with regards to Cedric, he started off as a visitor, but he became a non-visitor when he exceeded his permission. And I always like to quote Scruton LJ here from the case of the Calgarth, where he famously said, when you invite a person into your house to use the staircase, you do not invite him to slide down the banisters. So in other words, a person will become a trespasser if they go beyond their permission. And so under the 84 Act, there's a duty on occupiers in relation to trespassers. And although Cedric was going into the cellar with criminal intent, the law still protects those people. And you could apply Revel and Newbury there. There's going to be a lower level protection. Death and personal injury are the only protected forms of damage. So that means Cedric wouldn't be able to claim if he damaged property such as his watch. We then need to talk about section 1.3 of the 84 Act that says that occupiers are only liable where, and then there are 3 grounds, that they're aware of a danger or believe it exists, they believe another may come in the vicinity of the danger, and the risk is one which in all the circumstances he may reasonably be expected to offer the other some protection. So applying this back to the scenario, it seems that requirement B is not satisfied here because Arthur had no reason to believe that his guests are going to go into the cellar to steal his wine, nor would he be aware that there was a cork left on the stairs, and he wouldn't be expected to offer somebody protection from a cork on the stairs in the cellar that they weren't invited to be in. So therefore, no duty arises in respect of Cedric's injuries. So in conclusion, Clara should sue Basil for negligence in not looking after her correctly. Basil should sue the independent contractors in negligence for not doing the electric work correctly, and Cedric has no claim against Arthur whatsoever. Now remember, with law, you can always get credit if you've applied the law slightly differently, as long as you've justified your position with cases to support your points. So that was a whistle-stop tour through this quite complicated scenario question, but I hope that's been helpful in showing you how you could go about answering an occupier's liability question, particularly if it involves multiple characters and both Acts of Parliament, which it probably will. And you might like to practice using these subheadings to see if that makes it a little bit easier for you. So do remember there are other videos on the channel that will help you with occupier's liability as well as other areas of law. And please do like the videos if you find them useful, because it really helps me to make more content for you.